Hello, everyone. Hello again. I got a quick response that uh, to provide people wanted more information about the conflicts in between jurisdictions, in between federal law and local and state law, um, especially regarding um, deadly force use. There's some inconsistency. And to be really honest, I don't follow popular news that much, so I'm not familiar with or some of the cases that maybe people are talking about. But um, to begin with, to cut through all of the confusion, I'm going to state this very clearly, and this is for attorneys and judges and everybody involved in this in the legal process. If you read the Constitution of the United States, Article 6 describes the Constitution of the United States that we've all agreed to the, um, as the supreme law of the land. So nothing in the United States can supersede or conflict with the Constitution. So, state constitution, you read any state constitution, that's how it begins, with agreeing to follow the federal constitution. That's what the United States are. They're a conglomerate of states that have agreed to abide by the one um, establishing document that we're all in agreement to be the correct one, and that we're going to self-correct any changes in the law too. That's why Article 5 is what makes the Constitution scientific, which is the one that the amendment that allows us to amend the Constitution. Right, if we find out something is incorrect, something that gives us a better understanding of the law, it allows us to change the Constitution. So Article 6 makes it the supreme law of the land. Article 7 or Article 5, correction, um, makes it amendable, means you can change it. And being able to change something is what makes it scientific. And making it scientific is what makes it legal. Okay, so anything that contradicts the U.S. Constitution is going to be incorrect. It's a wrong, what we call an individual judicial interpretation of the law, which, not to get too, you know, far out there, but is what we call a high crime, which is a due process crime, which means you're interfering with the self-correcting process of the law. High crimes are very serious, and individual judicial interpretation um, is sedition under Title 18, Chapter 115, which deals with treason, sedition, and subversive activities. So, so the people who are having these confusions over the deadly force use um, is it's just bad lawyering. It means your lawyers are not appealing that situation all the way up to um, the article level of the Constitution. So um, that is the long and short of that is that if you're convicted of a homicide um, for a deadly force use that you feel that you had the law on your side, then it's a matter of you need to get that appealed up to a judge who is um, on the right sheet of music, who understands that uh, we, as long as you're representing due process, which is what the Constitution is about, that is the law. So, meaning the scientific method for dispute resolution, meaning we're not going to jump to conclusions. We're not going to have a bias going into we're not going to put our thumb on the scale of justice. We're not going to have a vested interest in the outcome of that experiment before it's conducted in an impartial laboratory, which is the courtroom. So these home defense laws and so forth being prosecuted differently in smaller jurisdictions is not all that common, or it's not all that uncommon, because you're going to have way less qualified people in those prosecuting positions than you would in a big jurisdiction, New York City, LA. Those people don't have time to have a bias. They have thousands of cases to get through. So they're much more automated, more impartial about their process. But in smaller communities, they're bored. They're, a case makes newspapers. They're gonna want to try to milk it for some, publicity or whatever. So just be mindful that the Article 6, the Constitution is always going to be the supreme law in the United States of America. That's what makes the United States of America, is that Constitution. So you cannot legally be in disagreement with the Constitution in the United States. So very briefly, so I don't confuse this really already complicated issue, when we talk about the law, when we talk about the Constitution of the United States, the what's called the original intent of the Constitution, the reason the founding fathers sat down and hammered out this agreement in the first place, was to guarantee everyone in the United States those inalienable rights to life, liberty, and the pursuit of happiness, which are in the preamble of the Constitution. So those are the guarantees that that all law is in support of. So that's what we mean by, if a law contradicts the Constitution, it means it's contradicting the original intent of the Constitution, which you cannot do. The interesting was, and I don't want to go off on a biblical tangent, and I'm not going to pass around a collection plate, but it is helpful to know that the original intent of the Constitution, those guarantees, is the same thing as the Golden Rule described in the Bible, Matthew 7:12, and some other places, that to treat others as we wish to be treated, right? And so that's when we're in public, right? You can do anything you want to inside your own property that's under your control. But in public, we agree that we're going to treat others the way we like to be treated. That's fair. That is completely fair. And then the law prescribes remedies for what to do if someone does not agree to that reciprocity, it's called. So like if you're when we say with the Rule 12.3 public authority defense, we believe in our heart of hearts that we have the law on our side, it means we believe in our heart of hearts that this is the reciprocity that the law protects, that you don't have a right to take someone else's life without due process of law, right? So you're going to carry out a death penalty against somebody. That person has multiple opportunities throughout the appeal process to present new evidence that says the original verdict was not fair, that they were not the ones who committed the crime. So, and if they can't do that, then um, you know, we don't worry about the specifics of the crime. What we worry about is that their rights to appeal that verdict are protected, and that their rights to be innocent, be considered innocent until they're proven guilty in a impartial courtroom by a jury of their peers, is protected. So that's very important. Number one, not only as a prosecutor, you don't want to hand somebody a defense grounds for a dismissal on appeal. If you just mistreat them in, in pre-trial, but also that's the right that we have, and then um, to be considered innocent, so that just getting a set of handcuffs on doesn't wreck our political career or business uh, earning power or or anything like that. So we want to be always consider someone as innocent until they are proven guilty beyond a reasonable doubt by a qualified, summoned and selected jury. Okay, so I don't want to belabor that too much, but that's uh, what you need to keep in mind when it comes to conflicting jurisdictions. The Constitution is always the supreme law of the land under Article 6. And if your actions are consistent with that golden rule, and you are still, being considered guilty over that, then that needs to get appealed up and the law fixed so it doesn't keep happening to people in the future. Okay, so I'll leave it there.